Hi, and welcome back to my channel. Today's video will address questions on most every client's mind when they come in for an estate planning consultation. What does it actually mean to have a trust-based estate plan? How much does it cost to have a trust? And is that cost really worth it, or am I wasting money? So what is a trust-based plan? Having a trust-based plan simply means that you do have a trust and that the trust is the primary controlling document in your plan. That is, the terms of the trust will govern distribution of your assets following your passing. Other types of planning can be done through the use of a will as the primary document. This generally means a probate proceeding will be necessary. Using beneficiary designations or transfer on death, payable on death designations can often be a very effective and efficient way to handle the transfer of your assets. Another planning option is to strategically title your assets to ensure that the right person receives them after you die. In my opinion, every client brings a unique set of circumstances to an initial consultation. It's really important to candidly and thoroughly discuss the client's wishes, their financial picture, and their family members or other intended beneficiaries. Once I can understand these important details about a client, I can recommend the best or optimal estate plan for them. In many circumstances, I do recommend an estate plan that includes a revocable living trust. In other cases, however, a trust really is not necessary to accomplish what the client wishes to accomplish. How much does it actually cost to have a trust? Of course, most clients wonder how much it will cost to have a trust drawn up. And I'm going to give you a lawyer's favorite answer, and that is, it depends. I know that that answer is not very helpful. So let me say that in my practice, generally the cost of a trust-based plan can range anywhere from $1,800 to $7,500, with, I'd say, the majority costing somewhere between $2,200 and $3,300. Now, I understand that that is still a fairly big range. The cost does depend on numerous factors. One, the complexity of a client's family situation, which can often mean whether there's a blended family. Two, any concerns that a client may have about the intended beneficiaries. That is, how old or mature are the beneficiaries? Do any of the beneficiaries have a disability which qualifies them for public benefits? Are any of the beneficiaries having financial difficulties, addiction issues, or another type of struggle? Another factor that goes into establishing the cost is how detailed a client wishes to be regarding the terms of distributing their assets. This means, are you satisfied with general language allowing distributions for the beneficiary's health, education, maintenance, and support? Or do you wish to be more specific? That is, do you want to expressly authorize the trustee to distribute funds for a beneficiary to purchase a home? Do you want to expressly allow distributions for undergraduate, technical, or trade school tuition, but restrict distributions for graduate level education? A trust allows you to provide exactly as you see fit. A trust also allows you to provide for numerous contingencies. Another factor is the nature and overall value of your assets. By this I mean, does the value of your estate meet or exceed the amount which will trigger an estate tax? If so, more complex planning may be desirable to eliminate or minimize estate tax liability. A couple other points regarding costs. This video and the discussion of the costs of a trust is really limited to the preparation of a revocable trust, which is also referred to as a living trust. This is the type of trust which is most common in estate planning. Note, though, that there are many other types of trust: irrevocable trusts, supplemental needs trust, special needs trust, charitable lead trusts, grantor retained annuity trust, just to name a few. The cost for any of these types of trusts is very likely to be different from the cost of a revocable trust. Also, different law firms set their fees in different ways. After our consultation, I will provide a client with the overall fee for the estate plan. This is called a flat fee or a fixed fee agreement. This fee will include all of the parts and pieces of your plan, not just the cost of preparing the trust. So, this means that all of the necessary documents for your trust, but also any real estate deeds, and if you desire, your power of attorney, your healthcare directive, and HIPAA authorization will also be prepared. This fee also includes a review of all of your assets to make sure any titling or beneficiary designations coordinate and cooperate with your trust. With many years of experience, I can accurately anticipate how much work and time will be necessary to complete your plan. So the fee that I offer you will represent what I believe to be fair compensation for the legal work to be done. I like the fixed fee because you, as a client, know upfront what the costs will be. There won't be any surprises or add-ons that you didn't expect. Other attorneys may charge an hourly rate for preparing your estate plan, and still others may offer something sort of a la carte. That is, one charge for a will, another charge for a trust, and another charge for a power of attorney. So, is the cost of a revocable trust worth it? We'll look at the questions you should answer to determine whether a trust is worth it. You'll see that many of these questions are basically the same or very similar to the considerations that go into determining how much a trust-based plan may cost. First, who are your intended beneficiaries? The answer to this can be very clear to you and therefore very straightforward, or not. If you are not sure who or which organizations you would like to name, don't let that stop you from starting your estate planning. In my experience, the decision on naming your beneficiaries becomes much clearer as you're talking things over with your attorney. Second, do you have any concerns about any of your intended beneficiaries being able to responsibly manage an inheritance? And, related to this, how much control do you wish to have over the future distribution of your assets? To answer this question, think about your beneficiaries' ages and maturity and any other personal factors that may impact how they may manage an inheritance. For example, are your intended beneficiaries your independent adult children who are each living responsible or relatively responsible lives? Then a trust may be overkill. Your wishes may be accomplished with accurate beneficiary designations. If, however, you have minor children or your children are still young adults, you may wish to have a trust in place to manage the distribution of the assets to them. Similarly, if your beneficiary has a disability or other issues which cause you concern, again, a trust is often the best way to make sure your assets are distributed appropriately and not wasted. Another factor in your decision will be the complexity of your family makeup. That is, are you a single parent? If you're married, do either you or your spouse have children from a previous relationship? There are a myriad of personal circumstances to consider, and a trust may be very helpful in addressing the concerns that arise under various circumstances. Another consideration is the overall value of your estate. If planning to avoid or minimize estate taxes is desired, a trust will be required. If estate taxes are not a concern, other planning options may be very satisfactory. Note, though, that the overall value of your assets is only one asset-based consideration. I have recommended and clients have agreed to have a trust in cases where really the only asset is the homestead. Clients choose this because of various family dynamics. In addition to the overall value of your assets, another question is, what is the nature of your assets? Are you a renter with a checking account and an IRA? In this case, a trust would likely offer no benefit. Or do you have multiple financial accounts? A trust offers a good way to ultimately consolidate or at least to organize your assets for efficient distributions to your beneficiaries. What about real estate? Do you own your house? Do you have a cabin? Do you want that cabin to stay in the family for future generations? Do you have real estate in multiple states? Again, a trust may be the best way to manage the disposition of your real estate. Do you have any business interests? What other assets do you have? Identifying your assets and analyzing the options for passing them on after your death will go a long way in deciding whether or not a trust is worth it for you. Another consideration is how important is avoiding the probate process. Probate is a court proceeding to transfer decedent's assets. It can be a long, drawn-out process, often taking well over a year to settle an estate. It is public, that is, the information about your assets and debts and intended beneficiaries are all part of the public record. Probate also has costs associated with it. There are court fees, publication fees, and often attorney's fees. Again, the cost of probate proceedings will vary greatly, but as of the date of this video, in 2026, I would say that except for the most straightforward matters, you can expect to spend at least $2,000 in a probate proceeding. When you have a well-drafted and fully funded plan, the trust will avoid probate. Finally, after your trust is in place, are you willing to take the necessary steps to fund your trust? Will you be diligent in making sure any future assets are properly tied to your trust? Having a trust prepared as part of your estate plan is only the first step. To reap the benefits of the trust, you must fund your trust. That means retitling assets and/or updating beneficiary designations to name your trust. You must also properly title any future asset you have or purchase. Generally, the work of funding the trust falls to the client. It is not a task for the attorney. I give my clients complete instructions on what to do, but it is the client's responsibility to make sure that the work gets done. Failure to properly address all of your assets now and in the future will greatly diminish or even fully eliminate the value of your trust. In that case, the cost of a trust will have been a waste. To wrap up, let's summarize. A trust-based plan is likely a waste of money if, on the whole, your family circumstances or other beneficiary choices are straightforward. You do not have concerns about your beneficiary's future management of their inheritance, and you don't feel it's necessary to control distributions. Your assets can be efficiently transferred with other probate avoidance options, and estate taxes are not a concern. Alternatively, a trust-based plan is often of great value when you have a blended family and want to ensure that all assets ultimately land where you intend. You want to ensure that your assets are well managed for your young beneficiaries or beneficiaries with challenging circumstances. Privacy is of high importance to you. Your assets are more complex, particularly if you own real estate in multiple states. Estate taxes are a concern. Ultimately, the decision on whether having a trust is worth it will be made after fully discussing and considering all of these matters. If you have any questions from today's video, or if you'd like to discuss whether a trust-based plan would be beneficial for you, please contact me. Thank you.